Good morning, folks. This is the Colorado Energy and Carbon Management Commission. It is Wednesday, what is it, the 6th, and it is 10:30, and we have a agenda before us that is not typical. Before we get into that, we will recognize our existence with a roll call.
Thank you. Commissioner Ackerman?
Here.
Commissioner Cross?
Present.
Commissioner McGowan?
Here.
Commissioner Messner?
Here.
Commissioner Oath? Commissioner Ray?
Here.
Commissioner Robbins?
Here.
Thank you. You have 6 of 7 commissioners present, Chair.
Very good. Welcome to each and every one of you to our meeting. The agenda today is twofold. It starts with an executive session, and then there's some presentation from the AAG as well as Wendy Padilla from DNR in an educational format. I think we should flip that script and start with the presentations from either AAG Davenport or Ms. Padilla.
Thank you, Chair. Is Ms. Padilla in the attendee list? Or oh, there she is. Great. I think we thought about her going first. So Ms. Padilla, please go ahead.
Thank you. Thanks for having me today. I appreciate it. I'm with Wendy Padilla, Chief Operating Officer with the Colorado Department of Natural Resources, and I've been visiting all the boards and commissions to give this short training this year. So I'll go ahead and share my screen. All right, so I'll go ahead and get started. We'll cover several topics today, which is about the Department of Natural Resources, our budget process, our code of ethics, accessibility for meetings, media contacts, and then our legislative policies, procedures, and timelines. Note that Kyle will cover all the other items listed here in either the meeting today or executive session. So about the department, we manage and conserve Colorado's natural resources for the benefit of people today and tomorrow. We have 6 divisions that manage water, land, wildlife, minerals, energy resources, and outdoor recreation. And we have a budget of about $494 million with more than 1,600 FTE, 1,100 plus temporary employees, and 6,000 volunteers. You can see kind of a breakdown of all of the divisions and the budget. Note that the Executive Director's Office also includes special programs, which is the Wildfire Mitigation Program, as well as the Avalanche Information Center. A little bit about our budget process. It begins in March, and that's approximately 16 months prior to when the funding is available. The Executive Director's Office works with staff to identify needs, and on November 1st of each year, that budget becomes public and delivered to the legislature for consideration. Between November and January, the Joint Budget Committee considers our request and the governor's budget. And in February and March, the JBC decides what is then codified into the long bill, and each chamber of the General Assembly reviews and proposes amendments, and that budget becomes effective July 1st. I'll go through our code of ethics now. And this was put in place a couple years ago to standardize ethical standards, transparency, accountability, and excellence by really describing the behaviors and expectations that we model. And all board and commission members should strive to meet or exceed our 8 tenets of the code of ethics, which are to advance the public interest, uphold the Constitution and the law, promote public participation and partnerships, strengthen equity, diversity, and inclusion, empower adaptive leadership, demonstrate personal integrity, promote ethical actions, and advance professional excellence. A little bit about accessibility. The ECMC does this really well. Some of our boards and commissions have not yet invested in technology to allow for a lot of accessibility at public meetings. But just to go over our ideals, which is to promote the accessible workplace and environment, facilities and public meetings. Any member of the public who wants to participate could request an accommodation through our ADA coordinators. And then it's a best practice to include accessibility statements on notices for meetings, including timelines and who to contact. And then meetings should be accessible to the public, either in real-time live streaming via video or audio. And then an option for virtual attendance and virtual public comment is always a best practice. Physical meeting locations should have sufficient bandwidth to accommodate virtual attendance if possible. Going over media contacts, members of the media may contact individuals, and to ensure transparency and accountability, it's important for board and commission members to remember that commenting on official actions requires coordination with ECMC staff liaisons and public information officer. Every board or commission may also and will also have additional unique guidance to the board and commissioners. And finally, legislative matters. DNR's Director of Legislative Affairs, who's Daphne Gervais, coordinates all communications with legislators and all department-initiated legislation. If contacted by a legislator, refer them to the Director of Legislative Affairs, and then ECMC staff that would normally handle that as well. And Daphne's contact information and her email address is below. As a department in the executive branch, we don't take positions on bills unless approved to do so by the governor. We may take the positions of support, oppose, neutral, or no position. And boards, commissions, and other DNR public bodies shall not take positions on bills in their official capacities. The legislative director will have information and be able to liaise on any particular department position we take on a particular bill. Any individual member can take a position in their personal time, not acting in their official capacity. Thank you for what you do. That is the end of my presentation, and I'm happy to take questions.
Thank you very much, Ms. Padilla, for the presentation. Does commissioners have questions? Well, short and sweet to the punch. Great work. Thank you very much. Mr. Davenport.
Thank you, Chair. Thank you, Commissioners. And thank you, Ms. Padilla, for that presentation. I'm going to share my screen. I have a presentation as well. If you'll give me one moment, please. Great. Hopefully you can all see that now.
Yep.
Okay, great. Commissioners, I'm going to cover, as Ms. Padilla suggested or noted, a variety of topics, many of which are already familiar to you. So I'm not intending on going through all of this in a great level of detail, but I do want to hit some highlights on things. In general, I'll be covering CORA, open meetings law, ethics and conflicts of interest in a little more detail than Ms. Padilla covered. First up is CORA, just noting that the statute does state the policy and purpose behind CORA, which is to make all public records open for inspection, and to give anyone who's interested in seeing public records the ability to do that through a request. I would note that a CORA requester does not have to explain why they're making the request, doesn't have to show any type of nexus to what they do or the purpose of the request. Virtually anything that's kept as part of your work for ECMC or any staff members work for ECMC constitutes a record under CORA, which means that the default is always that that record is publicly available for disclosure upon a request. This is just examples of the various things that can be considered records. Virtually anything, as the previous slide noted. Finally, we get to what's not a public record. Your personal private communications are not public record, as well as any of your personal private records. Obviously, as employees, you all have your own email addresses for state work, and it is best practice to keep those things as separate as possible so that we don't have any confusion should we get a CORA request that might inadvertently disclose anything personal or private. There are a number of exceptions to Cora, exceptions meaning something that would be a public record, but for an exception specifically stated in the Cora statute. Certainly your personal information is an exception, also privileged information. There are a variety of privileges that apply in Cora that are specifically laid out in statute. I think the two ones we deal with most commonly are attorney-client, which I don't need to go into more detail. I think they are any communications where you're receiving legal advice from me or another attorney in my office who represents you is protected by that privilege. Deliberative process is intended to protect pre-decisional and deliberative communications or notes or other documents that allow an agency and its employees to make decisions, work through issues in a manner that does allow the agency to keep those sort of pre-decisional deliberative documents from disclosure. This is not an absolute protection. It can't always be outweighed by the public's interest in disclosure. And Cora does provide for a process whereby if a requesting party disagrees with an agency's response, that can be brought to court. I'm not going to go into the attorney-client privilege, but if you have any questions about that, please let me know. Cora does have some specific timelines for how quickly we need to respond, and it is a limited time period. The default is 3 working days, which can be extended to 7 working days. So it's a pretty quick timeline, and if when we receive a Cora request that may include your records, that is something that we need you or staff members to get on pretty quickly because of this very short time frame. We generally do, when we receive a Cora request, consult with the requester if we have questions or want to determine how to, if we need to narrow or they want to narrow that request. There is a fee for responding to a Cora request. That involves the work done to prepare the Cora request, and in the interest of reducing the cost, we do confer with requesters to try and determine exactly what they're looking for and if there's a way to make that cost less for them and still get the information that they want. If we receive a request, you must retain all documents that should be responsive to it. That's not just for Cora requests. It also applies to a litigation hold, which is where we have active litigation or believe litigation is reasonably anticipated. We should hold on to records that might be relevant. That concludes the Cora portion of my presentation. I'm going to turn to open meetings law now. But please stop me at any time if you have questions about any of this. So OML, Colorado Open Meetings Law. Ooh, my computer was not paying attention. There we go. Again, the purpose of this, overall purpose is stated in the statute, is transparency and to prevent agencies, local governments from making decisions in private and then going into public session just to simply confirm that they made that decision, also called rubber stamping. The requirements, basic requirements, fundamental requirements are 3, that the meetings held must be open to the public so that they can listen to your deliberations, listen to all portions of the hearing, and that requirement does not require public participation. Obviously, we have a rule that provides for public comment, but open meetings law itself does not require participation from the public in order for it to be a public meeting that's open to the public. In addition to the meeting being open to the public, there's a notice period that's required. We must give the public advance notice of when the commission is holding a public meeting and do our best with recognizing that things may come up at the last minute, but put onto the agenda, especially what formal decisions the commission may make. And then finally, meetings of those minutes. Open meetings law does define what constitutes a meeting. that if it meets these 3 requirements, any communications or meetings, so emails, texts, anything where you are communicating constitutes a meeting. Any communication between 2 or more of you commissioners constitutes a meeting. And then finally, the subject of that communication must be where public business is discussed or official action is taken. There is an exception to meeting in open session, and that's one that we'll use after my public presentation. That's going into executive session. Process is we announce the purpose and topic of that executive session. It is one of the rare things that requires a 2/3 vote rather than just simply a majority to pass. The commission can't make decisions, adopt policy, or deliberate in its executive sessions, and those are recorded as well. These are best practices. This presentation, by the way, will be available to you and the public after this, but I think these are pretty fundamental and basic. You'll receive certainly emails and things like that, replying all as a practice to avoid. Please reach out to me or another attorney who represents ECMC if you have any questions. And in general, open meetings law prohibits your discussion, as you know, of ECMC business outside of a public meeting. So the last main topic that I'll cover in this presentation is ethics and conflicts of interest. There is a statute, the Colorado Code of Ethics, that applies to you and any employee in general of the state. That lays out these 3 kind of main areas, the fundamental duty of commissioners and any public officers to act in the public trust, and that you have a fiduciary duty, essentially the highest duty to act for the people of the state of Colorado. It prohibits you from doing and other state employees, public officers from doing certain things. I've listed them here. I think many of these are probably self-evident. It prohibits using confidential information you may gain for your own financial benefit. It prohibits gifts that may be designed to influence you or reward you for an action that you've taken. And then it prohibits you from taking other actions where you may obtain a financial benefit or using your position to help yourself or family members in certain ways. The statutes provide significantly more detail here. This is certainly not everything that's contained in those statutes. And if you ever have a concern, certainly please reach out to me or another member of my team. In addition to this statute, the Colorado Code of Ethics statute, there is a constitutional provision, Article 29, Section 3 of the Colorado Constitution prohibits public officers from receiving anything of value. There's also, and I'm giving a little more detail there, there's also a state body, the Independent Ethics Commission, that issues guidance and can provide opinions on what may constitute a problem under this portion of the Constitution, the gift ban. It sets a dollar amount, which I believe is currently $75 as a limitation on things you may receive, the value of those things. It also, in addition, the IEC provides through its opinions and advisory policy, provides significantly more detail based on questions it has received or cases that have come up about what may or may not be a violation of the gift ban. This can apply to many more things than certainly just someone giving a public officer cash or some item of value. It can apply to trips. Those are the obvious, I think, things. Free admission to things, those kinds of things can all apply under the gift ban. We also have our own conflict rule, that is Rule 514. It does provide for standards of conduct and what may constitute a conflict. in general, if you have an actual conflict, and we've kind of already gone through what may constitute a conflict, especially the most obvious example is one way where you or a family member may receive a direct financial benefit as a result of a decision that is before you. That's an instance where you must recuse yourself. You also have the option of recusing yourself if you think that your participation in a particular matter may raise an appearance of impropriety. I will note that the IEC and gift ban and statutes do consider the appearance of impropriety to be as or almost as important as actual impropriety as things to avoid. So appearance really matters, especially in this instance. In terms of timing, you should recuse yourself before any substantive discussions are had or the matter really begins in front of the commission. And if you do recuse yourself, you must physically remove yourself or leave the Zoom and not participate in any way. I think the most important thing for this conflict rule and conflicts in general is if you ever have a concern, please talk to me or another member of my office. And the default, I think, is always, even if you don't think there's any reason that you shouldn't participate, disclosure is always the best practice. That covers my presentation. I'm happy to go into executive session now, unless you've got questions about anything that I just covered.
Any open session questions from commissioners? I think, as you mentioned, Kyle, this is stuff we've gone over before. I think we appreciate the refresher that's required by statute. At this time, I would ask if any commissioner feels there is a need to go into executive session for further legal advice on any of these issues. And seeing none, that's not mandatory. That was just precautionary, right, Kyle? Putting it on the agenda.
It's on our agenda. So we do have a pre-scheduled executive session to cover questions and some additional topics, especially regarding jurisdiction authority and standard of review. So
okay. I would move we go into executive session for the reasons as stated in our agenda.
Second.
Motion and a second. All those in favor signify by saying aye. Aye. Any opposed? Okay, if you are a regular follower of ECMC, you will know what I'm about to say, which is that the commission is now going to enter into executive session for the reasons I set forth in our agenda. What that entails procedurally is we will leave this meeting and then we will go into a different Zoom meeting with the commissioners and our legal attorneys. We will conduct said executive session, and then when we're done, we'll come back to this meeting to exit the executive session to confirm that no decisions were made and to then adjourn the meeting. With that, we will leave this meeting now. I do not know how long this will take. Maybe 30 minutes is a guess, and we will return in a bit. And if you are so inclined, feel free to stick around so that you can see us when we come back. See you in a bit. Thanks. All right, this is the Colorado Energy and Carbon Management Commission. It is December 6th. It is 11:41. We are returning from an executive session. I would like to recognize Assistant Attorney General Kyle Davenport.
Thank you, Chair. We're returning from the executive session as noted in the agenda for the purpose of commissioner training and receiving legal advice and analysis on training on various topics stated in the agenda. No decisions were made. No votes were taken in the course of that executive session. And we now need a motion to exit executive session.
So moved.
Second.
Motion and a second to exit executive session. All those in favor signify by saying aye. Aye.
Aye.
Okay, we are now out of executive session. We have no further matters on our agenda, so I would look for a motion to adjourn.
So moved. Second.
Motion and a second to adjourn. All those in favor signify by saying aye. Aye.
Aye.
We are adjourned. See you next Wednesday, folks, for our next business agenda.